SJC-12413, 126 Self-Storage, Inc., and another v. Michael Sullivan.
Good morning, Mr. Manley. Don't take the departure of people to think that we think this case is any less important than the last one. And you may proceed.
Thank you, Mr. Chief Justice. May it please the court. My name is James Manley. I represent the plaintiffs' appellants here. There is something distinct, different, and more problematic afoot when the government selectively infringes on a fundamental right. That's Justice Gorsuch when he was on the 10th Circuit, striking down Colorado's lopsided contribution regulations. And when the Federal District Court in Kentucky considered a law very similar to this one, the solution there was to allow all entities to control a PAC. It solves both the equal protection problem and the free speech problem that lopsided campaign contribution ban creates. A total ban simply goes too far. Every time that the Supreme Court has confronted a ban on direct corporate contributions, it is said that such a ban is closely drawn if it allows the establishment, administration, and solicitation of contributions to a PAC wholly controlled by the sponsoring corporation. From Buckley to Beaumont and even in Austin, the only deviation has been in Citizens United when the court said a PAC wasn't good enough. But Beaumont is still good law, and what Beaumont says is that a corporation must be allowed to control a PAC, and even that option is unavailable in Massachusetts.
Well, you know that the appellees disagree with your interpretation of Beaumont, and they point to the Minnesota plan case in the 8th Circuit, and then I can't remember the name of the 9th Circuit case, City of San Diego, maybe.
Yes.
They say that Beaumont does not stand for the proposition that to have this type of differential, you have to have corporations be able to contribute to PACs.
Right. Well, two responses to that, Justice Lowy. The Minnesota case, we have to take the 8th Circuit at its word. And so what the 8th Circuit said was that the Minnesota PAC option was the same as the PAC option in Beaumont. Now, it turns out it's not. And later, when the 8th Circuit confronted Iowa's ban on direct corporate contributions, the 8th Circuit used the exact same language to say that Iowa has a PAC option just like Beaumont, and in fact, Iowa does. Now, we shouldn't double down on the 8th Circuit's mistake here and ignore what the Supreme Court said in Beaumont, that the corporation has to wholly control the PAC. And that makes sense because the speech of one entity cannot substitute for the speech of another. If you have a PAC that is controlled by the employees that the corporation cannot even pay administrative expenses for, let alone control the distributions, then how is the corporation speaking? How is that an outlet for corporate speech?
Could retail associations, corporate associations, such as the Chamber of Commerce or a local retail association, make a donation like that?
No, Your Honor, not if they have corporate business members. Those nonprofits are also prohibited from contributing. And in the 9th Circuit case, is before McCutcheon. And McCutcheon is really critically important here because what McCutcheon says is that independent expenditures are not a substitute for or an excuse for onerous direct contribution limits. And that's the basis of the 9th Circuit's decision in the San Diego case. The 9th Circuit says, well, independent expenditures are available, and so we're going to look the other way on this ban on direct contributions. Now, in the 9th Circuit case, that was a ban on all groups contributing, not just businesses. So we have a little bit of a different situation there as well. But the important point is that it comes before the Supreme Court's decision in McCutcheon, which tells us that independent expenditures cannot substitute for direct contributions.
If I can try to understand the world you're asking us to create in Massachusetts, under the law as you would have us apply it, a corporation, whether it be 126 or GE or Raytheon, could essentially contribute to a PAC which is devoted to a single candidate.
Yeah, well, yes, Your Honor. The OCPF actually has a couple of options. All we're asking for this court to say is that whatever campaign finance laws apply to unions and nonprofits should apply to businesses
Well, that's a
as well.
separate issue, and as you know, we need to address what the rules are for that. But
Absolutely, yes.
you have two arguments. One is that argument, and the other is that this restriction is itself, wholly apart from what may happen with regard to unions and nonprofits, is itself, or at least, I mean, that's my understanding. Are you saying that you only have one argument as opposed to two?
Well, if Section 8 is declared unconstitutional, then that solves the discrimination between businesses and
Okay, so
and
you're
nonprofits
saying
and
that your
unions.
only argument is the discrimination argument, that you were content if businesses can only do what unions can do?
Yes, Your Honor. We're not asking for any special treatment here. We're asking for equality and fairness across the board for all entities. So if that turns out that the law allows all entities to control a PAC, as is the case in Kentucky, as is the case in federal law, as is the case in 45 states, then we're content with that outcome. If OCPF determines that the law actually allows groups to contribute up to $15,000 to candidates, as OCPF currently understands the law, then we're okay with that outcome as well. But that's not a question this court has to decide.
Well, you say that, but obviously you're asking us to assume that that's the law, aren't you?
Well, yes, and for the constitutional question, it doesn't matter. So if our complaint is against the unequal treatment imposed by Section 8, so if the bulletin that allows for the $15,000 contribution limit makes the discrimination worse, of course, but whatever the precise contribution limit is for non-businesses, whether it's $15,000 under the bulletin or $500 from a PAC under Section 6 of the law, as so long as the business limit is zero, we have a constitutional problem. And the $0 limit is imposed by Section 8. That's why the bulletin is really beside the point. If OCPF stands up here today and says we disavow the bulletin, the constitutional issue remains exactly the same because the discrimination is imposed by Section 8.
Chief, are you done?
For now.
Yeah, so I'm trying to understand how much of Austin is left. Because Austin is a case that says that you can treat corporations differently. In Citizens United, the U.S. Supreme Court says nothing doing in independent expenditures, but it's not clear if it completely guts Austin and that analysis right in the campaign contribution context, right? How do we know there's no longer an ability to distinguish between corporations and unions, for example, under that old line of U.S. Supreme Court thinking?
Well, Your Honor, so the Eighth Circuit in Minnesota, citizens certainly thought that Austin had been gutted, and what the Eighth Circuit did in that case was remand to the district court for application of what it described as essentially strict scrutiny, and expressed skepticism that the defendants would actually be able to meet their heavy burden in the void that's left by the lack of Austin. Now, interestingly, on remand, the plaintiffs did not press this PAC issue, and I think that's why we have this confusion in the Eighth Circuit about this issue, because it just simply went away of its own accord, and the court was never really confronted with what is exactly the PAC requirement. But Citizens United rejects all of the rationales in Austin. The idea that protecting dissenting shareholders is a legitimate government interest, rejected by Citizens United.
Just to accelerate you a little bit, there were like 4 different parts to Austin. They've clearly gutted 2 parts of Austin, right? The shareholder part, and go ahead.
Anti-distortion is the other, which defendant here calls wealth generation. And there's a tremendous amount of discussion about wealth generation, which is astonishing to me because of what both Citizens United and then McCutcheon, a contribution case, says about wealth generation. The fact that someone spends an extremely large amount of money in an election is not a basis to regulate contributions.
I'm focusing in on the anti-corruption part.
Right, that is still good law, yes.
And so that's what I'm trying to understand. If there was a part of Austin that says that there's a concern about anti-corruption in campaign contributions, and there's some residual distinction, I'm asking, that's a question, not a statement. Is there some residual distinction between unions and corporations left in the U.S. Supreme Court law on the anti-corruption point?
No, Your Honor, and there's certainly not one that.
How do we know that? Because we're not supposed to project, right?
Certainly. This court does have the ability under the Massachusetts Constitution, of course, to go beyond what the Supreme Court has said. And of course, this court decided the union half of Citizens United in Bowie 64 years before the U.S. Supreme Court got there. So there's no reason that this court has to defer to the U.S. Supreme Court.
Bowie's?
Yes, it's B-O-W-E.
And what did we do there, remind me?
Striking down a total ban on unions spending any money in support of candidates.
And so
No.
you're saying that Bowie suggests, but again, I'm focusing on the mirror image of that, which is there's some sense that we have heightened concerns on anti-corruption for corporations.
Yes, and there are two reasons that Austin does not suggest that concern is legitimate in this case. There is no evidence in this case that a ban on even limited contributions is tailored to prevent quid pro quo corruption. And the burden is on the government. As McCutcheon reminds us, when the government restricts speech, the government bears the burden of proving the constitutionality of its actions. And so the only evidence that the defendant has presented is evidence of individual contributions leading to corruption, not corporate contributions. That's despite the fact that LLCs were allowed to contribute in this state until 2010, and there are no examples of quid pro quo corruption in all that time. There are 28 states that allow direct contributions, no examples from those states.
The trial judge brought up the DeMacy case, right, where we've got a corporation sort of ingratiating itself with the Speaker of the House, right?
But again, those are individual contributions that were supposed to go to the benefit of a corporation. But here's an even more important point in McCutcheon. What the Supreme Court says is, looking at the whole scene of campaign finance law, we have unlimited independent expenditure limits. So if someone wants to ingratiate themselves to a politician, if they want to set up an illegitimate quid pro quo, the way to do that, according to McCutcheon, is through the unlimited independent expenditures, not through $500 contributions.
U.S. Supreme Court says we're more concerned, that's free speech. They're concerned with the anti-corruption in the direct campaign contributions, right?
And here's the other point from Austin that's important to keep in mind. Austin does not address corruption the way that we need to understand corruption in the law today, because Austin talks about corruption in a different sense, not quid pro quo corruption. When Austin and Beaumont use the word corruption, they're talking about something different. Michigan's regulation in Austin aims to a different type of corruption in the political arena, the corrosive and distorting effects of immense aggregations of wealth. That is not corruption anymore. That is not quid pro quo corruption. That's a different conception. And Beaumont talks about the same concerns. So when Beaumont and Austin talk about corruption, they're not talking about where we need to be talking about today, which is evidence of businesses buying favors. And there just isn't evidence of that. And we have 45 states that allow corporations to control political action committees. And the defendant has not pointed to one example of those limited contributions from businesses leading to corruption. All we have are individual contributions, which would still be illegal under Section 10 if they're designed to disguise the source of the contribution.
Well, let me ask you that. If you were to prevail, if Mr. Jones could pay the maximum amount to a particular candidate individually, Mr. Jones creates a one-person corporation. Does Jones, Inc. get to pay that same amount to that particular?
I think that would be illegal under Section 10. It would be designed to disguise the true source of the contribution. That's not the situation we have here. We have long-standing businesses.
Okay, well, what if it was a smaller corporation, not a one-person corporation, but Jones Brothers, Inc.?
And if the corporation has no legitimate source of income other than the donations that it received from the Jones Brothers and then gave to a candidate.
Which means that we're going to be asking.
That's a Section 10 problem, I think.
We're going to be asking the campaign people to be saying, please show us your corporate books to make sure that you are a viable entity when you
Well, if they have some concern about this circumvention problem, and that's what they've done. That's what the record demonstrates, is that in all of these cases, these are Section 10 cases. These are cases where the source of the contribution has been concealed, and the good people at OCPF have figured that out up to this point. I don't see why they couldn't figure it out going forward.
What if Jones Inc. was an entity that happened to be owned by, say, Russian tycoons?
Well, again,
who owned 100% of the
OCPF
shares? Would Jones Inc. still be able to give money?
OCPF has demonstrated an ability to use Section 10 to determine whether a contribution that is coming from a legitimate source.
But they
And it would
haven't
still
had to
have
do it
that-
with regard to corporations, because corporations are barred from.
Well, and we have the experience of the 28 states that allow direct contributions, the 45 states that allow corporations to contribute through PACs, as well as the federal government. And all we're asking for here is equal treatment, and there is no evidence.
I
that
guess the
equal
question
treatment-
is, has the world changed? We now obviously have a concern about the potential for foreign manipulation of elections. If only individuals can give, that concern is relatively easily enforced. Does it become equally easy to enforce if we allow corporations to give?
I think it does for two reasons. One, the record here shows that OCPF can use Section 10 to ferret out those attempts to disguise the source of a contribution.
And tell me again how you would do that. So it says Jones Inc. paid candidate A the maximum, and how are you going to know who owns Jones Inc.? Well, the Secretary of State will have the name of the board of directors and the officers, who may not be foreign. They could be here.
But OCPF has that same problem right now. The Russian government could send money to Jones himself, and Jones could contribute $1,000 to the candidate. More than you could through the PAC. And McCutcheon confronts this argument, this idea that there would be this spread of political action committees to try to circumvent the aggregate limits that were at issue in that case. And what the court says is that that's just not realistic. In a world where you can spend unlimited amounts of money on independent expenditures, it's not realistic to think that the way that corruption is going to get into the system is through $500 contributions. And the court has to look at what is realistic under the full state of the law right now. And there just is no evidence in the 45 states that allow PACs, in the 28 states that allow direct contributions from businesses, that equality leads to corruption.
Now, the U.S. Supreme Court has not yet knocked out the federal bar against corporations giving campaign contributions.
No, and this court doesn't even need to say that corporations are constitutionally entitled to give direct contributions. What this court should say is what the Supreme Court has said up to this point, which is that at the very least, the corporation needs to be able to wholly control a political action committee and solicit contributions through that political action committee.
And if they cannot give directly to candidate A, why should they be able to give to candidate A's PAC? What's the difference?
Well, the Supreme Court has said that is a sufficient outlet for corporate speech, and it allows for more extensive disclosure.
Where has it said that?
It said that in every campaign finance case that I've been able to find, from McConnell to Beaumont.
It said that corporations can give to. It said that constitutionally corporations can give to a candidate's PAC.
Can control a PAC that then makes contributions to the candidate. Yes, limited contributions.
Tell me the case. Tell me the case.
Well, Beaumont is most directly on point, since it's
Beaumont, the issue
case.
in Beaumont, first paragraph, since 1907, federal law has barred corporations from contributing directly to candidates for federal office. We hold that applying the prohibition to nonprofit advocacy corporations is consistent with the First Amendment. That's the holding in Beaumont.
Well, and then Beaumont says that that law is closely drawn. In the last paragraph of the majority opinion, it says that the establishment, administration, and solicitation of contributions to a PAC wholly controlled by the corporation allows that law to be closely drawn, because what the court said in Buckley, the seminal case, is that the creation of separate segregated funds, political action committees, is a sufficient outlet for corporate speech, and that corporations and unions can spend unlimited amounts of money under federal law administering those political action committees, soliciting contributions from individuals, disclosing all of the contributions that come in, disclosing all of the contributions that they send out, that control of a PAC is a sufficient outlet. And so this court would be taking a step back from liberty, a step back from what the Supreme Court has said in all of its cases.
So
about
the cases
PACs.
that you say that, you say Beaumont, I know that, and where else do you say that the U.S. Supreme Court has said that corporations are entitled under the First Amendment to contribute to a candidate's PAC?
McConnell says that at 203. Beaumont says it at 149. Austin says it at 660. Buckley says it at 29, note 31.
Okay. Can I ask one last question on in Austin again? I'm reading from a part of Austin. Moreover, labor unions differ from corporations in that union members who disagree with a union's political activities need not give up full membership in the organization to avoid supporting its political activities. Although a union and employer may require that all bargaining unit become union members, the union may not compel those employees to support financial union activities beyond those germane to collective bargaining. Is that distinction still viable, or and if not, why?
It is not, Your Honor, and that is the only distinction that this court has drawn between unions and businesses in First National Bank. But what Citizens United says is that protecting dissenting shareholders from being compelled to fund corporate expression that they disagree with is not a legitimate basis for banning corporate speech. What the court said is that the remedy is not to restrict speech, but to consider and explore other regulatory mechanisms. The regulatory mechanism here, based on speech, contravenes the First Amendment. That's Citizens United at 362. There are other ways, and what the court has consistently pointed to, again in McCutcheon, is disclosure as the way.
That was too subtle for me. Explain that to me, that because they've rejected the idea about shareholders and corporations, they necessarily then reject this idea of union members and their views being. You lost me on that.
Well, what the court is telling us is that if we're concerned about protecting dissenting shareholders, the way to protect them is not to ban corporate speech. The way to protect them is to consider and explore other regulatory mechanisms. So shareholders have the ability to control the corporation, the vote in the corporation that they're a member of.
They're analogous to union members. Is that what you're saying in this?
I think that's a fair analogy, and union members have procedures to protect them under Hudson, and shareholders have procedures to protect them as well. And the court pointed to that at the discussion in Austin at 360. I'm sorry, in Citizens United at 362. The idea that protecting dissenting shareholders, that the only way to do that, that the constitutionally permissible way to do that is by banning corporate speech, it was emphatically rejected by Citizens United.
Now, before you sit down, as soon as the defendants get up, they're going to talk about corporations and unions not being similarly situated. What's your response to that argument we're going to hear?
Well, the only basis for that is in the response brief is that businesses are specially situated to generate wealth. And the Supreme Court has told us that wealth generation, that anti-distortion, those are not legitimate government interests anymore. And it's an especially flat argument here in Massachusetts, where nonprofit corporations are free to give to candidates on the same terms as unions. Nonprofit corporations have the same state-conferred advantages to generate wealth. Some are extremely wealthy, probably much more wealthy than my clients. No offense to my clients. But this idea that wealth generation is a legitimate distinction that campaign finance law can look to discriminate against speech, the Supreme Court has said that is not legitimate anymore. We do not accept wealth generation as a distinction between entities, whether it's businesses and nonprofits or businesses and unions.
All right, thank you. Ms. Kobik?
Good morning, Your Honors, and may it please the Court. The Commonwealth's bar on corporate contributions remains as constitutionally sound as it was when the legislature enacted it 100 years ago to address the risk of quid pro quo corruption and its appearance, and as when the Supreme Court upheld its federal counterpart in Beaumont. Now, I want to emphasize an important point that Mr. Manley didn't address, which is that since Buckley, the Supreme Court has recognized there's a fundamental distinction between independent expenditures and contributions. Independent expenditures are direct speech, but contributions involve a transfer of money between the contributor and the politician who receives it, who then may or may not use that money to fund her own speech. So the Supreme Court has said contributions lie closer to the edge than to the core of protected expression. And for that reason, the standard of review that this court applies to review restrictions on contributions is very different than the standard of review that applies in the independent expenditure context. It's the closely drawn standard. The Supreme Court has described it as relatively complacent or deferential. And that sets the context for this court's review in this case, and it's important. Beaumont emphasized that when you have a contribution restriction that's existed for over 100 years, the court owes deference to legislative line drawing on that.
It's not quite as simple after sort of the dismantling of Austin, is it? I mean, it's difficult to think of the U.S. Supreme Court's allowing different types of treatment of unions versus corporations versus nonprofits. How do we justify that without Austin? Because Austin provided a really strong support for that distinction, but it's been almost completely eviscerated.
So I think Your Honor was correct to describe Austin as having 4 holdings. And I agree that Citizens United eviscerated 2 of them, which is that there's no longer a shareholder protection interest and there's no longer an anti-distortion interest. So the government now, when it regulates contributions, it has to act in furtherance of its interest in preventing quid pro quo corruption or its appearance or the circumvention of contribution limits. But what the Supreme Court didn't do was eviscerate Austin's under-inclusivity analysis and its equal protection analysis. And Citizens United nowhere said...
But Austin doesn't have much equal protection analysis, does it?
It relies principally on its under-inclusivity analysis.
Why would the anti-corruption concerns be heightened against... Why are they stronger against a corporation than a union and a nonprofit? Because not all nonprofits, we got all kinds of different kinds of nonprofits too.
Yeah.
So why is this, what do we turn to? What do we turn to for support? Because your brief turns pretty heavily to Austin, and I'm just not sure how much of Austin is still out there.
I want to make clear that the government can act to prevent the risk of corruption and its appearance. When it's doing that...
I completely agree with that, and I don't think there's any doubt about it. The question is, can they draw distinctions the way they've done here?
Yes, and the answer is yes. When it's doing that, acting in furtherance of that interest, it doesn't have to ignore the facts as we know them to be, which is, are there distinctions between entities that would support acting against one entity to prevent corruption versus not another? So yes, the anti-distortion interest, the interest in equalizing resources between speakers is gone. But in furtherance of the preventing corruption, the legislature is still entitled, particularly under the closely drawn standard, to address one aspect of corruption without addressing all potential aspects of the problem.
But but that I don't quite get, because we're talking about a constitutional right, and to use the Chief's First Amendment analogy, aren't we talking about viewpoint discrimination in that context, which is where we heighten our focus?
2 points, Your Honor. So this fits into the plaintiff's under-inclusivity argument. And as an initial point, I'd refer the court to Williams-Yulee, a 2015 Supreme Court decision, where Chief Justice Roberts said there's no under-inclusivity limitation under the First Amendment. The legislature is entitled to proceed step by step and address particular aspects of the problem as it sees fit. It doesn't have to address everything that it could conceivably regulate at one time. That said, the way that under-inclusivity fits into the analysis is does the omission of a certain entity undermine the government's justification for its action? So does the legislature's decision to regulate corporations but not nonprofits undermine its justification for regulating corporations, or is there some impermissible viewpoint discrimination here? And on both those questions, the answer is no. There's a very robust record showing that there is a risk of corruption and the appearance of corruption when corporations
But
can make...
I mean, we've got a history of bad guys on both sides. You know, we've got the old Teamster stuff from the Jimmy Hoffa era. We've got, you know, bad corporate behavior. Do we really have a record that we're going to be able to say, well, there's more fear of corruption on the corporate side than there is on the union side?
We unquestionably have a record that there is a fear of corruption on the corporate side, and I'm happy to point this court to some of those cases, including the cases that involve the circumvention of the contribution ban by having corporations use employees as conduits. Those are Section 8 and Section 10 cases. I don't think it's appropriate to view them only as Section 10 cases, because if you look at the consent agreements, they involve a violation of Section 8. There's no question about that. There is no record of union corruption, and I certainly would agree that historically, I accept that there has been a history of that, but it was the plaintiff's burden to introduce evidence that its comparator entities are similarly situated.
Because he's saying that you've drawn, who has the burden in a constitutional analysis? Because does the government have to support its distinction, or does he have to prove that the discrimination against him? Which cases tell us who has that burden? Because I think he's going to argue the opposite, that when government gives a benefit to one and not you, it's your burden to support that.
Under this court's decision in DuPont, the plaintiffs carry the burden. And as a general matter, and that's for the equal protection claim, the plaintiffs carry the burden to establish that they're similarly situated to whatever entity they choose to compare themselves to. And I'd argue because the equal protection under inclusivity analysis are similar.
And that's a free speech case, DuPont?
That's an equal protection case.
But equal protection covers all kinds of stuff. It's not an employment case you're referring me to, right?
No.
It's a political contribution case?
No, it's not a contribution case. I believe it involved differential treatment of male and female prisoners.
Oh, but that's a whole nother world, isn't it?
Well, as a general principle, it's just well established that a plaintiff carries the burden of proving it's similarly situated in any equal protection case. The Superior Court cited a number in its decision. I think that's an established principle. As to the under-inclusivity analysis... And
just, you know, it's well established, so tell me some U.S. Supreme Court cases that put the burden on the challenger here.
I believe I've cited the DuPont decision. The First Circuit case in Aponte Ramos is another one. That said, the OCPF, again, can act incrementally, and it doesn't carry the burden to imagine any potential comparator that a plaintiff might say is similarly situated to that plaintiff, right? The plaintiff has to make his case. He comes into court and says, I'm being treated dissimilarly from another entity, and this is why the court should regard us as similarly situated. And I think Austin is important here because the Supreme Court, and Austin hasn't been abrogated. On these 2 points, I'd point, Your Honor, to the 8th Circuit's decisions in Minnesota Citizens and Iowa Right to Life. There are differences between unions and corporations, or nonprofits and corporations, that would justify the legislature regulating corporations as it's done here. And principally, Abood is that difference, Abood and Beck. So unions can't spend all of their general treasury resources on political activities. They have to segregate out the dues from objecting members in a way that corporations don't have to segregate out funds from objecting shareholders.
Your brother just argued, and I asked him that question because I'm wondering if that's still good. He says, well, the analysis of shareholders is comparable to the analysis of union members, and we should reject that rationale. Why isn't he right on that?
His answer was tailored to the Supreme Court's discussion of the shareholder protection interest. I agree that interest no longer exists, but the difference between how unions have to segregate their money and how corporations can handle their money is relevant to the anti-corruption interest at issue in this case as well, which is what is the likelihood that an entity can use its general treasury funds to extract a quid pro quo from a government official. And so the fact that the shareholder protection interest doesn't exist anymore is irrelevant to that analysis. It's a separate question. And so I think Austin remains binding on that point, and the plaintiffs haven't made their case to show that they're similarly situated to the comparator entities. Now, I'd like to address Mr. Manley's other argument, which is that under Beaumont, this court has to demand a corporate PAC option identical to federal law. And Beaumont didn't hold that at all. If you look at Beaumont, what it requires is that corporations have the ability to engage in some participation, that's a direct quote at Penn site 163, in the federal electoral process. And so the court said, all right, is there an opportunity for corporations to have some participation? And one outlet for participation was the federal PAC option available under federal law at the time. But at the time, corporations were restricted in how they could engage in direct speech through independent expenditures. The world has changed since then because of Citizens United. And now in Massachusetts, corporations have more opportunity than ever to engage in some participation in the federal electoral, or in the state, excuse me, electoral process.
So that's one of the things I've been thinking about, as we try and understand this doctrine and where we are after Citizens United. How important it is that when we look at all these cases to differentiate between rights to political expression and political contribution?
I think it's the question under the closely drawn analysis are there other avenues for corporations to influence state elections? And there isn't a sharp dividing line between the avenue through corporations and through independent expenditures. And I don't think McCutcheon at all says that independent expenditures are not an adequate outlet for speech. That was a case about aggregate contribution limits. It doesn't say, you can read it, it doesn't say anything that independent expenditures shouldn't be considered. The amicus brief presents compelling evidence that spending by corporations has exploded since Citizens United. So corporations can now make their own independent expenditures, direct speech supporting or opposing candidates. They can form independent expenditure PACs and fund those PACs through corporate money. That's a way to directly influence state elections that didn't exist before. All of the other cases that Mr. Manley points to besides Beaumont were strict scrutiny cases, but this is a contribution case that involves closely drawn scrutiny, the more deferential and less rigorous standard of review. So I'd point your honors to the Thalheimer case in the Ninth Circuit, where the court said the ability to make unlimited independent expenditures pales in comparison to a potential $500 contribution through a corporate PAC or through a corporation.
So the fact that you can give millions on the independent expenditure stuff makes the inequality of the $15,000 insignificant? Is that essentially the argument?
No, I think those are separate concepts.
Well, but it seems like you're saying that Citizens United is the cure-all to the differential treatment point, because they've got plenty of opportunity to contribute into the political process. Therefore, the fact that they're at a disadvantage in one part of the system by $15,000, we should ignore. I mean, is that right?
I'm relying on the availability of independent expenditures to address their argument that Beaumont requires a federal PAC option. They've disavowed reliance on the interpretive bulletin and the $15,000 limit, so I don't think that actually comes into play.
I think they don't, that's not where their focus is, but you've got to defend the $15,000 difference, which is they can give zero, but unions and nonprofits can give $15,000 directly, right?
That is the state of the law as it stands today. That said,
And you're saying that don't worry about that because they're not shut out of the system because they've got this bonanza on the other side.
I think one could make that argument. I'm not here to actually defend.
I'm just trying to make sure you're not making that argument.
No, I'm not making that argument. And I think the amicus did point out that there are some compelling state law questions that, to the extent this court believes it needs to rely on the interpretive bulletin in the case, I don't think it's relevant, and the plaintiffs have disavowed reliance on it. But to the extent this court thinks that it does need to consider that bulletin in deciding the constitutional questions, the antecedent state law questions that amicus has raised make a remand appropriate on that. I don't rely on the $15,000 limit to defend Section 8.
So to pose the question you heard in the previous case, if you lose, what remedy is appropriate here? If there isn't allowed a distinction between unions and corporations on that, what's the remedy?
I think it depends on how this court were to write the decision. I think to the extent that it's concerned about the distinction between the $15,000 limit and the bar on corporate contributions, the remedy we would request is a remand for OCPF to engage in rulemaking on what constitutes a political committee under Section 1.
But the statute, Section 8, is a bar on all corporate stuff.
That's right. That's right. And for all the reasons that I've described, we think that's constitutional. The plaintiffs have made no argument other than reliance on the interpretive bulletin why the statute itself suggests viewpoint discrimination or any kind of protectual motive.
Well, no, they have a very direct argument. They're saying that corporations can't give assent and unions can give whatever is allowed by OCPF, right? And it's more than nothing.
Yes, but that argument only fits into the analysis on their under-inclusivity claim. And again, the under-inclusivity argument, I think, is
And the best case for under-inclusivity in contribution analysis or expenditure analysis is what? Because that concept to me, I have trouble doing it in the First Amendment context, but
I'd refer Your Honor to the Wagner case, which is an en banc D.C. Circuit opinion.
and
Chief
that's a
Justice
political contribution case or a political expenditure case?
It's a political contribution case, and it involved the federal law preventing federal contractors from contributing. So it's a little bit narrower than Section 8. But Chief Justice Garland goes through an extensive, under-inclusivity analysis where he looks at potential comparators that the plaintiffs addressed and said, as a general principle, Congress was entitled to proceed step by step. It wasn't required to address every potential comparator that you could imagine, and it rejected the under-inclusivity analysis. I'd also point, Your Honor, to the Williams-Yulee Supreme Court case, which involved judicial solicitation of contributions, so it's a little different. It involved a limitation on judges' speech, and so it was a strict scrutiny case rather than a closely drawn case. But it, again, walks through a pretty detailed under-inclusivity analysis and says, again, there's no freestanding under-inclusivity limit on legislatures. They're entitled to draw reasonable lines, and that's what the court held in Beaumont, and that's what the legislature did here.
Now, the under-inclusivity may bear on, in terms of whether or not the law favors a political viewpoint. Is that not something we can consider?
Yes, I believe Your Honors can consider it. And on that point, I don't think the plaintiffs have any evidence that the legislature, when it enacted Section 8, was intending to favor or disfavor any particular viewpoint. The only thing that they've pointed to was this interpretive bulletin, which was issued in 1988, 70 years after. Again, then they disavowed reliance on the bulletin, but to the extent this court believes it bears on that question, a remand would be appropriate to enable a CPF to address that issue.
Does it matter, your brother says, even if it's only that the union can pay up to the individual limit, it's still different that a corporation can't even do that. Would it matter in terms of the analysis of whether or not it's favoring or disfavoring a political viewpoint if it's $500 versus $15,000?
I would say no, Your Honor, and that would be a different case than the one presented here. But if that were the rule, then I'd say under the closely drawn standard of review, the legislature is entitled to draw the line that it did, and there would be a reason for regulating corporations and not unions, which again goes to Austin and the real differences between those entities. Of course, the legislature could regulate unions if it chose to. It just hasn't chosen to here, and it's entitled to draw that line.
Speaking of regulation, I gather nonprofits are subject to the Attorney General's review, correct?
Yes, I believe so.
So that distinguishes them from profit corporations in that the AG has some ability to monitor nonprofit corporations.
Yes, that is another distinction, yes.
How about with regard to unions? Are there regulatory restraints on unions that are not imposed upon corporations?
Off the top of my head, I couldn't list them for you. I'd be happy to submit a 16L letter on that point. I believe the difference depends on whether they're public sector or private sector. Private sector unions are mostly governed by federal law. Public sector unions are governed by state law. And I'd be happy to submit a letter on that if Your Honor would
Does the
like.
Department of Labor monitor the political contributions of unions? I know that it's a matter of great concern, but is that part of the auditing that is done by the Labor Department?
OCBF certainly does. I can't say right now whether the Department of Labor does. The Attorney General's office has a Fair Labor Division, but again, I'd be happy to submit a letter on that point.
Can I go back to your under exclusivity for a second? So there's got to be limits on it, right? You couldn't have a rule that Republican can only give 500 and
Sure.
Democrats can give 1,000, right?
Right, absolutely.
Couldn't do that.
Right.
And you couldn't have nonprofits on one side of an issue have a ban and nonprofits on the other side of the issue not have the ban, right?
Right,
So I'm
yes,
just-
yes.
So this under exclusivity is only good as long as it doesn't have a viewpoint component to it, right?
Yeah, to the extent that those on their face would have, be intended to favor one viewpoint or another. Everyone knows that Republicans and Democrats have different viewpoints on political issues.
We can't do the same conclusion that unions and corporations are often on the opposite sides of things?
I think they are, but there isn't a record on that point, and I do think that.
And we need a factual, because the trial judge made that point too. So we need a factual record to know that there's a difference between unions and corporations for the purposes of political campaign contributions.
It's not just that there's a difference between them, it's that the legislature had a protectual motive. So that's the question, was the legislature
Well, we
intending?
don't have to, do we really have to do it based on discriminatory intent or in free speech context? Is that how we do it?
Well, I think that's relevant, Your Honor. If the Wagner case is a good one to
Well,
look to
I
on
get
this
the
question.
Wagner case is drawing a distinction between people who have government contracts and those who don't, meaning people who actually have a relationship with the government, and they're rewarding the people who are contracting with them. It seems a little different than what we're talking about.
Well, a number of comparator entities were suggested, and the court walked through in detail, are these actually similarly situated? The plaintiff plaintiffs could have pointed to evidence that the legislature was motivated by some intent to discriminate. But I think it's relevant that at the time Section 8 was enacted, federal law also only applied to corporations. And it wasn't until much later that federal law was expanded to include unions as well. The plaintiffs just haven't, I think, met their burden to show that there was an intent to discriminate based on viewpoint here in Section 8 itself.
And does that, I guess that's a key issue, is are we focusing on discriminatory motive or discriminatory impact?
It's motive, Your Honor, and I think impact is relevant to that question, but all of the
We're saying impact is
under-inclusivity.
relevant only in that it may bear on the inference concerning motive.
Right, because whenever someone raises an under-inclusivity challenge, there will be a discriminatory impact in the sense that one entity is treated differently than the other, but that alone can't be, that would mean that the government has to regulate every conceivable entity at once, and that's not the rule. The rule is that the government can address problems it sees in a step-by-step fashion.
And refresh my memory, Section 8, does it address other entities or does it simply address business corporations?
It addresses business corporations, LLCs, LLPs. I can,
Okay, but it
Quote the
doesn't
language.
address the universe of other entities.
no. It
It just says
specifically applies.
these may not contribute,
Yes, that's right.
period.
That's right. That's right.
It does not say these can.
Right, it doesn't on its face, that's right. And
So
that might suggest more of an intent to discriminate if the statute had said these cannot contribute and these can, but that's not what the statute does here.
So the rest are simply, the statute is silent and it's left to them being governed by the usual campaign, whatever the prevailing campaign rules are.
That's right.
Okay,
Okay,
thank you.
thank you.
And I think we'll probably take our morning break.